show. We head now down to South Florida. Outside of Judge Eileen Cannon's courtroom is our friend Julie Kelly, who is in her car because you cannot take cell phones with cameras into the courtroom, which is basically every cell phone now. Julie, we appreciate you going outside of the courtroom. It sounds like there's been some fireworks, and I want to ask you about this right off the top because I saw your tweet, and we've talked about it a little bit on the show. It sounds like to you that Judge Eileen Cannon is potentially expressing some agreement with the idea that Trump is being selectively prosecuted for classified documents based on what has been determined by Robert Hur in his special counsel report about Joe Biden's own classified documents. Explain, even if it's not been a direct commentary on that, what you are seeing that makes you believe that.
Correct. So it was not a subtle suggestion by Judge Cannon on numerous occasions, asking both the defense, Donald Trump and his attorney, and also special counsel Jack Smith's team about historical precedent for criminally charging a former president for taking home classified or national defense information documents. And she raised the term several times, and she just did it again this afternoon. That was the morning session. I just came out after the afternoon session is ongoing, and calling this, arbitrarily decided, arbitrarily prosecuted. And so just to back up, what the hearing on today is two motions to dismiss the case, one based on the unconstitutional vagueness of the Espionage Act, which represents 32 counts against Donald Trump, and then also protections under the Presidential Records Act. As you guys know and your listeners know, that was how the origin of this whole investigation and then prosecution. I don't think she's going to dismiss the case on either one, but the feeling was she was using this hearing to sort of flesh out how this is so novel and unprecedented, especially in light of Robert Hur's report and then, of course, his testimony this past Tuesday. So Donald Trump shortly will be filing a motion to dismiss based on selective and vindictive prosecution. He hasn't yet, but he told the court last month that will be what he's doing. And I'm sure they're going to be pulling comments and quotes from Robert Hur's testimony Tuesday before the House Judiciary Committee about the willful retention by Joe Biden, willful retention of classified documents, including national defense information, at his various residence in Penn Biden Center for years, knowing that he had it, sharing it with a ghostwriter, but then declining to bring charges. So that's going to be the next big clash, I believe, in these proceedings.
Yeah, I mean, Julie, just to a layperson, it seems like if there is such a thing, if it's possible to mount any defense based upon selective prosecution, you have two guys running for president. Both are accused of having classified documents that they are not supposed to have. Put aside some of the more specific aspects of that. Trump was president, Biden was not, etc. But Biden was effectively excused by Hur in this case because he says the guy's old and he didn't mean it. Well, Donald Trump didn't mean it either. It just feels like, how could they allow this to happen, right? I mean, you've got both presidents. I think that they'd be on such stronger ground, in their minds at least, with this case against Trump if we hadn't just seen that Joe Biden had classified in 7 different places.
That is exactly right. And it was really interesting to watch Judge Cannon emphasize and really confront the government to say, well, your indictment about willful retention, the date of that is January 20th of 2021. So basically, she got the government, Jack Smith's team, to concede that, yes, the moment that a president leaves office and he takes with him documents that NARA, the archives, or DOJ, or whoever considers presidential records classified material, national defense information, the minute he leaves office, he is willfully violating the Espionage Act. And that was really a key moment for me because it meant you really don't have to prove willfulness unless you can demonstrate that while he was still president, he was hoarding these materials in boxes and telling people to send them to Mar-a-Lago. So what my takeaway was, she was saying whether Joe Biden knew he was doing it or not, the fact that when he left office in January of 2017, he took with him troves of classified material that he knew he was not supposed to have. Some of it was sent to the Penn Biden Center. Some of it was at a rental house in Virginia for 2 years, then his home in Delaware, in a garage, in an office, laying all over the place. It really kind of distracted or took away from the willfulness element of these charges. What the government is saying, the minute you leave office, whether you're president, vice president, or whoever, and you have these materials in boxes, which, by the way, you didn't pack. Of course, Donald Trump didn't pack them, neither did Joe Biden. And you take them, that represents the willful retention of national defense information, and you are violating the Espionage Act. So I think that sort of tipped off that would be part of, if when she is considering and holding a hearing on selective vindictive prosecution, that is going to be a key question that she will want answered.
Julie, you also dropped what I think is really a significant part of all of these cases, and I have not seen it receive the attention that I think it deserves. General rule is the Department of Justice doesn't want to step itself into a political process, and so they tend to not be involved with cases that are occurring in the fall surrounding a election, even maybe making the decision to do the Mar-a-Lago raid in the summer of 2022, if I remember, because they didn't want to do it in the fall. Okay, just bring that up for this reason. Jack Smith and his federal prosecutors, according to your reporting, again, I think this is a really big deal. They said, oh, that Department of Justice rule that we generally ascribe to, it only would apply to new indictments. It wouldn't apply to actual trials. I read that argument, and it almost made my brain want to explode, because if you're concerned about the political impacts of indictments, the idea that you could actually have a trial and that they would try and argue, oh, no, this would be less significant. We just couldn't bring a new indictment in the fall. We could have a trial. Even people who are left-wing have to hear that argument and think, boy, this is a load of manure that is, even for the Jack Smith prosecution team, a different level of manure, right? I mean, it's crazy to me that could be their argument, but they made it down in South Florida.
Not only did Jack Smith make this argument, Attorney General Merrick Garland stated very clearly in an interview a few months ago that he considers both of these matters, the classified documents case here in Southern Florida, the January 6, 2020 election interference case now on hold in Washington, he considers both of those matters out of the hands of the Department of Justice. They are now in the federal court system. The judges are responsible for setting the trial dates and handling all the pretrial motions and jury selection. The DOJ, as soon as it got to the judges, as soon as they started to set trial dates and pretrial schedules, it now is in the hands of the courts. So that's why I keep saying, and you guys, we've talked about this for years now, no one should be surprised if the Supreme Court comes back and upholds lower court rulings that Donald Trump is not immune from prosecution, that he will stand trial in Washington in early September, late September. We know now that the DOJ will not stop it. They've already green-lighted it. And we know that Judge Tanya Chutkin, if this is put before her late September, early October, she has clearly said that the election calendar and politics plays no role in her courtroom. She's going to pretend none of this is even happening. So it was not just a stark comment made by, of course, the special counsel, but Merrick Garland himself, which I think is why they timed the indictments when they did. So they brought the classified documents case June, a superseding indictment in July of 2023, and a few weeks later, August 1st, the January 6th indictment. So they stacked these up with the timing, where it would go in the hands of the judges. They knew there would be all this pretrial activity headed up to the Supreme Court on a few questions, and that the DOJ could then come back and say, oops, sorry, it's out of our hands. When these go to trial, doesn't matter if people are voting across the country and Donald Trump is on trial in Washington or Southern Florida. Nothing we can do about it, folks.
It's crazy. Julie Kelly, everybody, Declassified with Julie Kelly is her Substack. Go subscribe to it. Julie, we got more to talk about as this goes along. Thanks for being with us.
Thanks, guys. Thanks for having me on.